For today's Toil and Trouble employment law slot, I'm talking to Charlotte Joy, a senior associate at BE Employment Law, about 90-day trials being extended to all workplaces and what employers need to know about how to best use them. Charlotte, thank you for coming in.
Thank you.
Are your employer customers, are they happy about this?
Yes, they do see it as another tool in their toolbox, but it has been some time for some of them that they've been able to use them because they're of that larger size. So there's certainly a lot of questions coming in about how can I use them? Can I do X and Y? So.
Right. And that's what you're here today to talk about, of course, some of the common pitfalls, because many cases that underpin employment court and ERA cases are to do with 90-day trials, aren't they? It's quite common, comes up as a problem.
That's right. And I think because of the impact of the individual, the courts have been clear that trial periods and trial period law should be strictly applied. So it's definitely something that they won't try and get around to suit an employer.
Right. So what are the common mistakes that are made?
Commonly, employers will offer employment on essentially an informal conversation. They'll talk about terms and there is an acceptance of that employment before an employment agreement is present. So that poses issues when a trial period is then given at the last second. Other common pitfalls are an employee not even being given an employment agreement until after they've started work, or haven't signed an employment agreement until after they've started work. So again, trying to introduce a trial period at that time is going to be unlawful.
So let's say you ask me out for coffee and say, look, I've got a bit of filing work in the office. I'd like to, talk to you about possibly doing some work for us. We go out for a coffee and you say, yeah, that sounds great. Why don't you come in on Monday? Or, yes, I agree to pay you this X, Y, Z. Can that still be done, or does there have to be caution about how that's
There should
done?
definitely be caution in that conversation. When you're talking about those key terms like I'll pay you X amount and you can start on Monday, that is going to be seen as an offer of employment, talking about those key terms. So you'd be far safer to say, look, we've got some work. We can only offer you around about this amount, but that's going to be subject to our other terms of employment as well, and we'd need to get you an employment agreement for you to look through.
So how best is it to set up a work trial? What are sort of the steps that you need to go through? You see someone, you think they'd be good, but you want to do things according to the 90-day trial law.
It's really not a work trial unless someone has accepted employment. So it would be unlawful to have a potential applicant come in and flip burgers for a couple of hours and then say, great, you have the job, here is an employment agreement. At that point, the individual has already done work for the company and it would already be seen to be an employee. So to trial an employee, you truly need to make sure that they have that trial period in place and they've agreed to it before they do their trial.
So as with everything, it sort of comes down to dotting your I's and crossing your T's properly and getting that employment agreement in place.
That's exactly right. And ensuring that the individual has an opportunity to seek advice on that employment agreement as well. That might be through asking questions, but also being able to, go talk to a lawyer if needed. So they need an opportunity to consider an employment agreement and consider important terms like a trial period.
And then what happens at the end of the 90 days?
So the key thing is to make sure you know when your 90 days ends. At the end of that time, before the end of 90 days, an employer can call an individual into a meeting and say, look, it just hasn't worked out. You're not a good fit. We're giving you notice of termination, relying on the trial period clause in your employment agreement. That will still have a notice period, but if the employment agreement is drafted right, you can then opt to pay in lieu of notice rather than getting that individual to work out the notice. So there still would be a notice period. For a trial period, it's normally only about a couple of days. but you still need to have a look at that clause and see what it says.
Right. What about people who are hired by temp agencies? I know there's a slightly different set of considerations there.
Yeah, so the starting point for trial periods is that they can only be used where there is a new employee, and that is very clear. So if someone has been a temp, regardless of whether they were engaged as a contractor, say, for that temping agency, or as an employee, and then at some point they get offered employment directly from, I guess you could say, the end user of that temping agency, despite that person already being in the business for a period of time, they could actually be offered employment on a trial period, and that could be lawful. There is some risk in that situation with any temping arrangement, that there is sort of a dual employment, a dual employer type risk. But if the temping agency is dotting all their I's and crossing their T's, that is truly their worker, and you could have a trial period for someone who has had the odd day here or there in your business.
That seems amazing that a company would pay a temp agency and then undertake a 90-day trial. You know, the whole idea, I guess, of getting temps, they are already looked at by that agency and sort of vetted. You know, do you think it'd be a common problem?
I don't think so, because I think that a lot of temps, I think, are a temp because that suits their lifestyle. So perhaps then going into permanent employment for the end user may not be something that they are as interested in. But that does happen from time to time, and could also happen in contractor situations as well. So you have a contract accountant working for you 5 hours, every week or so, or as needed, and then, you may get an offer of employment down the line that could have a trial period in it, which might seem bizarre because, again, you're not truly trialling that individual, but the key thing is that they haven't been an employee before.
So an employer doesn't have to have a 90-day trial period in the employment agreement, do they?
No, absolutely not. Probably more common in more junior roles. A more senior role, less likelihood perhaps of having a trial period. There is also a probationary period, which can confuse some employers. So that is similar in a sense, that it's a period to test the suitability of an employee, but there isn't the same protections around just being able to dismiss someone and not have any recourse in terms of unjustified dismissal claims. You still have to follow a fuller and fair process, more akin to standard termination processes.
Are you anticipating more work as a result of this law change?
Definitely. I think a lot of employers will be a bit complacent and will just chuck in a clause and not understand, I think, the dotting the I's and crossing the T's that they need to do at the start of that process to make sure it's enforceable.
Charlotte, thank you so much for coming in.
Thank you for having me.
To support our award-winning independent journalism, subscribe to nbr.co.nz.